So this unit second of the black one, it is a continuity of the basics of contract. So in the last unit 1, we studied what is a contract and what are the contents of the contract under section 10 of the Contract Act. Section 10 was clearly says all agreements or contracts when made by the free consent of the parties competent to contract and for a lawful object with a lawful consideration and not expressly declared to be void. So in the last unit, we have discussed what is the competency of the parties. The person who has a major and who is a person sound mind can enter into a contract, and what is the free consent, when a consent is said to be free, when a consent is not said to be free, that we have discussed. Now we come to the next point, that's the legality of the object. So any contract, a consideration must be there. Similarly, it must be made that consideration must be lawful and object must be lawful. Consideration means that has given by something. One person do something and reciprocally other person will also do something. So these promise and performances must for a lawful act. That means consideration must be lawful. Similarly, object. Object means for which purpose the parties are entering into a contract must be also lawful. So if the consideration becomes lawful or object of the contract or agreement is lawful, then the consideration is said to be void. So we have to know why and how that agreement is lawful and when a agreement becomes unlawful. So any agreement for which it is forbidden under the law, that means when an object of the agreement is unlawful, forbidden under the law. See, for example, under the Indian Penal Code, committing murder, committing robbery, committing house trespass, committing theft, these are all unlawful act. So law punishes for the person who makes it. In such cases, if any agreement it is forbidden under the law, for example, contract to commit a crime, if the both the parties agreed to commit theft or commit robbery, in such cases that object is unlawful, that act is void. Secondly, an agreement is of such a nature that if permitted, it defeat the provision of any law. That means if there is a law, so that is to be followed. If the parties made an agreement which is against to that law, that is object is unlawful. Say for example, pre-marriage agreement. If the parties agree to live separately after marriage, or if the parties agree to make second marriage after their first marriage, in such cases always it is against the law or it is defeat the provision of law, because in Hindu law, even under the Christian law, that polygamy is the rule. So one can marry only for the first time. If a person wants to make a second marriage, he must give divorce to the first marriage. He must be relieved from the first marriage. In such a case, any pre-marriage agreement between the parties, it will defeat the provision of law. In such cases, its object is considered to be unlawful, it becomes void. Then, is fraudulent or implies injury to the person or property of another, impose heavy penalty. That means any fraudulent act which results in injury to the person or the property of another, in such cases it is unlawful object and that act is void. Similarly, if any act, if the court considered it as immoral or opposed to public policy, there are certain policies under the society, it is to be followed. Say for example, all the laws are to make the society to keep in harmony. So any act which is against that public policy is considered to be void. Say for example, any agreement to run a prostituted house or trading with an enemy, these are all the things which is opposed to public policy, hence void. And then trading with an enemy. So when a war breaks out between the countries, so any such agreement at the time of war, it is void. Similarly, stifling prosecution. Stifling prosecution means it is a compromise of public offence. That means to make the compound of the offense which is uncompoundable. Uncompoundable means making a compromise of a case. If a person committing a crime makes an agreement with any considered or any police officer not to file a case or not to file an FIR. In such case, by bribing that police officer, it is nothing but a stifling of the prosecution. It is void under the law because that police is opposed to law. And champerty and maintenance. Champerty is the bargain and maintenance is the promotion of a litigation. Suppose if both the parties agreed to file a false case on a person and sharing the profit of that case, in such cases it is considered to be champerty, and the maintenance, it is opposed to public policy. Hage interference in the court of justice. Interference means making any problem, giving any trouble for the proceedings in the court of law. It is opposed to public policy. Similarly, for example, that is a marriage brokerage contracts, it is also opposed to law. And then it is considered interest against obligation. Suppose an agreement by an agent received without principal's consent, that means any obligation on the person. This is an example with respect to principal and the agent relationship. In a case, any act done by the agent on behalf of the principal, if the agent receives any remuneration or anything from the other party or a third party without consent of the principal, it is void under the law. So hence it is interest against the obligation. Sale of public office. That means any agreement to traffic in public office. Public office means any public servant have to follow the law. So any person makes an agreement with a public officer to make an unlawful act, that is considered to be a traffic in public office. It is opposed to public policy. Then agreement in creation of monopoly. Monopoly means in case of business, competition is always allowed, but unlawful competence, see, is always void under the law. We can give an example. The creation of monopoly means if any seller prohibits every other seller from selling the commodity in a particular area or in a particular city or in a particular district, that is nothing but the creation of monopoly. It is void under the law. Then agreement in intent of marriage, putting a condition not to marry this person or compelling a person to marry the same person, that is against to public policy. Similarly, agreement in restraint of trade, because every person can do whatever the business he wants. So any restriction made to do a particular business, it is void. And agreement in restraint of legal proceedings. Legal proceedings means if a person, aggrieved person, can file a suit for any damage or for any remedy, so any agreement not to file a case, it is against the law and opposed to public policy. Similarly, if all the section 10 of the contract act is fulfilled, all the essential act is fulfilled, that means competency is there, lawful consideration is there, lawful object is there, parties are competent, free consent is there, then in such cases, next question arises, performance of the contract. When all the essentials are fulfilled, the parties have to perform their part of the contract. So after performing their part of the contract is said to be discharged. So discharge is not only done by performance, but also not performed is also the other party can be discharged. The ways of discharges are, first thing is by performance. If the both the parties have done their part of the act, then contract is said to be comes to an end. Attempted performance means if one of the parties is ready and other party is not ready, in such cases the aggrieved party can discharge from the liability and sue for compensation. Third party, by lapse of time. If there is a limitation in case of debt recovery, so after the lapse of time, the other party can discharge from liability by operation of law. Operation of law means if the death or insolvency occurs during the pendency of the agreement, then the other party can discharge from the liability because all the contracts are of personal nature. It cannot be done by their legal heirs. So hence the contract is discharged. Then by mutual consent. Mutual consent means it is one of the reason by novation. Novation means any one of the new agreement is added in the contract, then new contract is said to be made and the first contract is said to be discharged. Again, rescission. Rescission means if any of the agreement has been terminated in their agreement, then also the party can continue with that or else they can discharge from the contract. Then remission, for if one of the party accepted for a lesser amount and other party denies it or not accepted, then also parties can discharge from the contract. Then by impossibility of performance. So after making or entering into an agreement, that performance can become impossible. Say for example, if two countries have entered into an agreement to do a business. So if the war breaks out between the countries, then business between the two countries is not possible. That is supervening impossibility, not known to both the parties at the time of entering into a contract, then a contract becomes discharged. Then destruction of the subject matter. Suppose unknowingly or without knowledge of both the parties, that subject matter of the contract is vanished or destructed. Say for example, A agreed to sell the house to B. Without knowledge of A and B, house is burned by fire. So that cannot be, contract cannot be performed. So hence it is discharged. And also death of the promisor, outbreak of war, and also change of law. In all these cases, the parties is said to be discharged. Suppose if the discharge takes place without fault of the other party, no one can claim compensation from the other party. Suppose if one of the party is faulty, because contract is discharged by fault of the other party, the aggrieved party can claim some remedies. Those remedies are, it is said to be breach of contract takes place. So what is a breach of contract? That is when one of the parties failed to perform the contract, the other party is considered it as a breach of contract. In such cases, one is the anticipatory breach. Anticipatory breach means after entering into an agreement, the one of the party has not agreed to perform the contract or failed to perform the contract, then it is considered to be breach. Then aggrieved party can claim for damages. Then other party can rescind the contract or he may cancel the contract and claim damages, or he can wait till date. The other party can wait till the date and afterwards he can claim the damages. And actual breach. Actual breach means if either party before not or failed to perform, then it is considered as an actual breach. So if the breach has been considered made in the contract, the party can ask for remedy. So what are the remedies? First thing is damages. Damages means if actual loss has been suffered by the one party, that party can ask the other party to make good the loss. That means whatever the loss he has suffered, he can ask for compensation. Not the profit, but actual loss. So what are the kinds of damage? One is ordinary damage. Ordinary damage means that arose naturally. As per the law, if actual damage has been suffered by the party, he can claim as a matter of right. Secondly, special damage. Special damage means if any special, under the special circumstances, if he has suffered a special loss. That means if the one of the retail person order for the delivery of a crackers in Diwali, but the wholesaler failed to supply the cracker within time. Because of that, he suffered a special damage, because he will put a profit on the crackers at the time of Diwali and not afterwards. So he must suffer a special damage. In such cases, he can ask for the special damage, but in this case, he must make known to the party that what sort of special loss he is going to suffer if the party has not fulfilled the contract. But any indirect damages, party cannot claim for damages. Then exemplary damages that is the, it's not actually the loss has not been made, monetary loss has not been there, but it is a loss for the sentiment or for the loss of goodwill. Say for example, breach of promise to marry. If one person promises to marry but later he refused, in such cases it is a damage caused to sentiment, because his damage, his sentiment will be lowered, his respect will be lowered in the society, so he can claim for damages. That we call it as a mental agony. And secondly, dishonor of check. In case that person who has caused dishonor, it is the loss of goodwill. In this case also they can claim damages. And then nominal damage. Nominal damage means actual loss. No actual loss, but he has to show that he has a right to claim. Say for example, in case of defamation, if a person or if one of the party blames the other, he will file suit for defamation. Defamation, it actually no damage is there, but he can claim whatever the amount he wants, that is a nominal damage. And then prefixed damage, that is the damage, the cost to be paid that has been fixed in the agreement before entering into the contract. Then penalty and liquidated damages. Penalty can be claimed as the way of punishment for the other party, so it may be higher than the actual damage. Liquidated damage is the approximate damage or a reasonable damage for the loss caused to the party. Then sue for quantum merit. Sue for quantum merit means as much as earned. That is, which if the contract agreement is performed, the other party can sue for damages for the remaining half of the contract. Then sue for specific performance. In some of the cases, compensation is not a right for the party, or if the party does not prefer to be claim for damages, or he may ask for the specific performance where the damage is considered to be inadequate. Say for example, in case of a not promised to marry, better he denies. In such cases, it cannot be compensated in terms of money. In such case, other person will ask for the specific performance. And lastly, sue for injunction. Along with the claiming for damages, the party can sue for filing a case for stopping that particular person for not doing a further any action. It is called a injunction order, can be taken from the court. So contingent contracts. Some of the contracts seems to be a special contract. So performance of the contract depends upon the happening or a non-happening of a certain event. Say for example, in case of insurance, if insurance company promised the insured to make good the loss if his house is burnt, it's a fire insurance. So in such cases, performance of the contract depends on the happening of a particular event. So insurance company makes an agreement with the insurer to make him good the loss if his house is burnt. If the house is burnt, he will be compensated, or if the house is safe, no amount can be given. That is called as the happening or a not happening of an uncertain event. Uncertain event means both the parties are not knowing whether that thing is happening or will not happen. So contingent contract is a contract to do or not to do something if some event collateral to that such contract does or does not happen. Say for example, A contracts to pay a certain sum of money if B's house is burnt. In such cases, if the house is burnt, the contract is valid. If the house is not, or house is safe, then for the not happening, the contract is invalid. Similarly, there are how that contingent contract is performed. So enforcement of a contract contingent on an event happening. If a parties are make a contract to perform the contract on the event happening. If A make a contract with B that he gives 100 rupees if a ship returns safely. If the ship returns, A has to give 100 rupees to B. If the ship sink or if the ship does not return, then contract is not said to be performed. Similarly, it is a contingent contract do or not to do if an uncertain event. So always event is uncertain or event is must be a future event, it must be uncertain. And enforcement of contract contingent on the event not happening. Even two persons can enter into a contract to perform their part of the contract if that event not happen. Say for example, A agrees to pay B a sum of money if certain ship does not return. That means if the ship does not return, A has to pay B money or else not said to be performed. So agreement contingent on impossible events. So if the event itself is impossible, in such cases that agreement is said to be void. So one cannot enter into an agreement with two impossible things. So it is said to be void. And next type of a special type of contract is a wagering contract. Wagering is they all parties always depend on the to pay money or money's worth if some uncertain event or happen or not happen. Say for example, A makes an agreement with B. I pay you 100 rupees if rain comes today. That means both the parties have no interest in the subject matter, but their interest is only on the happening or non-happening of an uncertain event. So such agreement, if the event is the sole determining factor and it is not a contingent contract and it is not, wagering agreement is not an illegal agreement but an agreement contracting parties have no interest in the subject matter and it is a void agreement. It is not, though it is not unlawful or illegal, but it is a void agreement. So any wagering agreement cannot be enforced.